WWE employee Janel Grant, Vince McMahon, and WWE have jointly asked a federal court in Connecticut to move Grant's high-profile S-trafficking and SA lawsuit out of public court. They're seeking to have the case resolved through confidential arbitration instead. Also, I apologize for censoring for YouTube's algorithm. In a joint filing submitted on June 11th, the parties requested that an upcoming June 16th hearing be postponed while they continue discussions on a potential arbitration agreement. If approved, the case would be resolved through a private legal process rather than through public court proceedings. McMahon and WWE have long sought to move the case to arbitration, citing a clause contained in a 2022 non-disclosure agreement signed by Grant. Until now, Grant had opposed arbitration, arguing that the NDA should not be enforced. The new filing does not explain why Grant's position appears to have changed, though the parties stated that discussing a confidential arbitration agreement that could render several pending motions unnecessary. Judge Sarah F. Russell has not yet ruled on the request. Grant originally filed the lawsuit in January 2024, alleging that McMahon SA'd and trafficked her while she was employed by WWE and that the company enabled or failed to prevent the misconduct. McMahon has denied the allegations and WWE has disputed claims of wrongdoing. The lawsuit led to McMahon's resignation from his position with WWE, and
I guess most people knew this was coming. Crazy. Welcome to the T-Drop, guys. If you've been here for the Janel Grant coverage this page has done, the 40-page declaration that she did, the Nick Khan breakdown that we went over, the NDA timeline, you already know the story. I'm not going to run through that today, but if you haven't yet, I will provide the link in the description for you guys to check out the full breakdown and start from there. We're going to go through what happened this past week with the Janel Grant case and how it got to this conclusion. We're going to go through some of the dominoes that led to this and see where we go from here. So the first domino, and this is the part most wrestling channels will probably never cover properly because it's not just a wrestling story when it comes to this whole situation. It's not even a wrestling story. It's a Wall Street story. On January 10, 2025, the Security and Exchange Commission, also known as the SEC, they charged them. And the reason was because they found that McMahon failed to disclose to WWE's board that he signed NDAs promising $10.5 million combined to 2 women, keeping material information from shareholders. Now, this is where it landed when it came to this. McMahon ended up settling. He didn't do any admission or denial, but he agreed to pay. And this is the SEC report from sec.gov. McMahon consent to entry of the SEC. The order further finds that McMahon signed management representation letters that were provided to WWE's auditor that did not disclose the existence of either settlement agreement. After learning the settlement agreement, WWE issued a restatement of its financial statements in August 2022. Now, company executives cannot enter into agreements on behalf of the company that served and without that information from the company's control functions, and auditor said Thomas P. Smith Jr., Associate Regional Director of the New York Regional Office. McMahon consented to the entry of the SEC's order, finding that he violated the Securities and Exchange Act by knowingly circumventing WWE's internal accounting controls, and that he directed or indirectly made or caused to be made false or misleading statements to WWE's auditor. The order also finds that McMahon caused WWE's violations of the reporting in books and records providing of the Exchange Act without admitting or denying the SEC's finding. McMahon agreed to cease and desist from violating those provisions to pay a $400,000 civil penalty and reimburse the WWE's $1.33 million, basically, pursuant to Section 304A of the Sarbanes-Oxley Act. But eventually, the breakdown is pretty straightforward. Civil penalty of $400,000 and $1.33 million reimbursed to WWE, which Vince ended up paying a total out of his pocket of $1.73 million. Now, in what universe does an innocent man write a check to the federal government? That's the question the IWC should be asking, but we will see what happens with them. The second domino, and I know you've heard Laurinaitis agree to cooperate before, but the finalized settlement is new. And the language is important because on May 28 of 2025, John Laurinaitis reached a confidential settlement with Janel Grant. He's dropped as a defendant with prejudice. She can never refile against him again. But it came with a string attached from the joint statement. And I quote, John Laurinaitis has agreed to cooperate and provide evidence in Janel Grant's lawsuit against Vince McMahon and WWE. Now, a pivotal next step towards holding McMahon and WWE accountable. Think about that though. The co-defendant, the man named in the office allegations in all these documents that we've seen so far, is now a witness for her side in a public trial. That's probably going to be a nightmare for McMahon. Remember that, because it makes what happens next in this whole case so much stranger. Now let's get to the twist and how she agreed to go private, which is probably the biggest question that most people will be asking. So here's where we are. SEC charged them, right? The co-defendant flipped and is feeding her evidence. Every piece on the board favors a public trial. At least that's what we thought a few months ago. And then on June 11th of this year, 2026, Janel Grant, Vince McMahon, and WWE filed a joint motion together asking the court to move the entire case into private, confidential arbitration. Crazy. And I can read a quick segment about it. Plaintiff and defendant have initiated dialogue and engaged in active discussion regarding a potential agreement to arbitrate the dispute in confidential arbitration. All parties are cooperatively proceeding the feasibility of this resolution path before proceeding further. We hereby request a joint stay of the litigation timeline to facilitate these conversations without incurring additional costs. Anyway, so they didn't want to deal with more allegation costs, but what does that mean? Now, this all means the parties are in active discussion regarding a potential agreement to arbitrate the dispute in confidential arbitration. June 12th, Judge Sarah F. Russell granted it. The public hearing that was set for June 16th, which is this Tuesday, was canceled. A joint status report is due, though, by July 10th. So with all that in mind, let me ask you something. This is Janel Grant, right? The woman who said on camera she had a whole public event in February that NDAs relocate harm to the next victim, right? Or something in those words, right? The woman who fought 2 years to keep those doors open, why would she suddenly agree to close them herself, right? It's weird. I'm not going to pretend I know. Her legal team hasn't as of yet said publicly why this is all happening, but two things can be true at the same time when it comes to this, and this could be a setup for a confidential settlement at the end of the day, or it could be a strategic call we won't understand for years, or probably won't know ever. Now, when it comes to this, when both sides suddenly agree on the one thing they fought hardest about, honestly, money is usually in the room when it comes to all this. Now, what does the arbitration do to this case? So basically, here's what this means for you as a person watching closely this story. Arbitration basically means it goes dark. There will be no longer any public filings, no depositions you'll ever be able to read, no discovery dump, or anything public. If McMahon, Khan, or anyone else was going to be questioned under oath in a way the public could see, that is officially gone. Now, that means no public testimony, no subpoenas, documents in the record. Any settlement amount likely will be sealed forever and we will never know. Now, the Laurinaitis evidence we just talked about, it may still matter inside that private room, but you and I will probably never see a word of it. And here's probably going to become the most uncomfortable part about this video. The federal criminal investigation is a separate track. As of today, no criminal charges have been filed. So the one place this could still become fully public is the DOJ, the Department of Justice. That's the only door left open at this point, and nobody knows if they'll even walk through it at this point. Now 2 years ago, this probably was the loudest story in wrestling. And it wasn't even a wrestling story. It was about something that was going behind the scenes when it came to the business. And as of this week, it's being walked into a room with no cameras, no referees, and so forth, if you want to go that route. And both sides are walking in willingly. Whatever you believe about this case, that should bother you, because now you will never know probably what's going to happen. And it is what it is at this point, because the thing Janel Grant said NDAs do is make a workplace safer for the institution than the people inside it. That's exactly the outcome we may be heading towards. And very quietly, may I add. The record so far: a resignation from TKO, an SEC charge, a co-defendant turned witness, and now a case going private. The story isn't over. It's just going to be harder to see going forward. And it is what it is. If that's how they decide to go going forward, that's going to be all for them. But for us, I think this is probably the end of this story for us. So anyway, drop your thoughts in the comments. Do you think this ends in a sealed settlement, or does the DOJ blow it back open? As always, if the T hit right, hit the like and subscribe, and I will see you on the next video.